respondent is not there.
Grounds under which the award is under challenge. The first ground that I've taken that no demand or dispute was raised by the concerned workman or by the concerned union before the employer that were rejected by the said employer and that could have led to an investor. That is with respect to the definition 2K, that I have earlier stated. Number 2, Your Worship, that concerned labor support Garai and the Janta Shramik Union, the union, has suppressed the material fact that it has filed a petition before the Calcutta High Court. Then the third point, with respect to memo or appeal that was dismissed on the ground of limitation. Therefore, the reference case number 32 of 2002 was barred by res judicata, and the fact about the filing of writ petition and memo of appeal before Calcutta High Court and it being dismissed was also suppressed by the concerned workman before the Labour Court and Tribunal. And the parties were the same before the Calcutta High Court also. Then reference is stale. With respect to the same, I have also submitted the judgment. Then support the right, that is the fifth point, who has admitted his guilt before the inquiry officer and before the disciplinary attorney. Therefore, he cannot take advantage on the ground of technicality. That support Durai has not referred departmental appeal against the order of dismissal dated 25th of June 1980. It has been wrongly held by the order dated 31st of August 2006 in reference case number that the domestic inquiry was not fair and proper. This finding is perverse and not
आपका आर्गुमेंट पूरा सुने तो नया ग्राउंड कहाँ से एडिशनल ग्राउंड का तो कोई अंत नहीं है ना things which you have not argued by you put it in writing like this. I will not accept it. Your arguments has been recorded and we have taken note of it. नया कहानी मत करिए नहीं ये this I will not permit. I heard you fully. I heard you full day. पार्टनर मैटर तो क्या उनके रेस्पोंडेंट का आर्गुमेंट के लिए है. रेस्पोंडेंट इज नॉट देयर. वी क्लोज द आर्गुमेंट. दैट्स इट.
बिकॉज़ इसमें जो हम लोग प्रोसीडिंग दिखाए हैं ये लोग बोलते हैं कि प्रॉपर नहीं हुआ था. हम लोग का 8 या 9 गवाह हुआ. सबने ये क्रॉस एग्जामिनेशन का इनको मौका दिया. ये अपना गिल्ट को एक्सेप्ट किए और बोले कि हमको कोई क्रॉस एग्जामिनेशन नहीं करना है. बाद में जब इनका गवाह हुआ तो ये भी वहां पर भी अपना गिल्ट को एक्सेप्ट किए और क्रॉस एग्जामिनेशन हुआ. फिर इनसे पूछा गया कि आप फर्दर कोई अपना डिफेंस में गवाह देना चाहते हैं तो वो बोलते हैं कि नहीं हमको कोई गवाह नहीं देना. एंड इट हैज बीन हेल्ड बाय द लेबर कोर्ट की इनका डिपार्टमेंटल प्रोसीडिंग जो है वो फेयर एंड प्रॉपर नहीं. Therefore this finding is not sustainable.
और पैराग्राफ कहाँ है? वो ऑर्डर कहाँ है? whereby the inquiry was held to be fair and proper.
वो मतलब मेरे पास नहीं है.
तो हम उसको कैसे स्क्रूटिनाइज करेंगे? बहुत अच्छी बात है. You are just wasting the court's time.
No, not at all wasting the time.
Why if you wanted anything, then you should have said at the threshold. What is this? And you just see the order that the order is there in the counter affidavit. You did not produce anything before the court to show that the inquiry was fair and proper. Even the proceedings of the management, you see, the management has not been able to examine any witness in support of the fairness of inquiry. They have not filed the original domestic inquiry proceedings. कुछ भी मत ऐसे बोला करिए ना. Within the domain of law, you can say you have not produced your domestic inquiry proceedings, and you say cross-examine किए ये किए. कहाँ से बोल रहे हैं? From which document are you saying this?
पूरा डॉक्यूमेंट को हम लोग यहाँ पे लगाए. एंटायर प्रोसीडिंग को लगाया.
क्या चीज एंटायर प्रोसीडिंग लगाएं?
जो डोमेस्टिक इंक्वायरी हुआ था उसका पूरा प्रोसीडिंग को एक-एक
अरे भाई कोर्ट में नहीं प्रोड्यूस किए हैं आप. गलत लिखा है क्या? You have not said that this has been wrongly mentioned in the order.
फिर मेरा 8 पॉइंट है कि the finding of the presiding officer in paragraph 9 of the impugn award dated such and such that no reference can be rejected on the ground of delay is against the decision of honorable Supreme Court. मैडम वो हम दिए हैं डिसीजन सुप्रीम कोर्ट कि अगर डिले है, अनएक्सप्लेन्ड डिले है, इसमें इस पर्टिकुलर केस में 19 साल का है, नो एक्सप्लेनेशन हैज बीन गिवन विद रिस्पेक्ट टू डिले, और हाई कोर्ट में लोग गए उस बात को भी छुपा लिए। और जो नीता कपलिस वाला केस तो ये लोग रेफर किए हैं, that is reported in 1999 volume 1 SEC 570। इसमें कोर्ट जो है मैटर को रिमांड बैक किया, बोला गया, उसमें देखा जाएगा नीता कपलिस वाला सेक्शन में बोला कि दोनों पार्टी को दिया जाए मौका टू एग्जामिन विटनेसेस, दैट इज द फाइंडिंग। और इसमें कोर्ट बोला, इसमें एक और आया है कि कोर्ट बोला इसमें कि आपको कोई गवाह देना है कि नहीं मेरिट को, उसके बाद वो गवाह नहीं देते। हमको कभी बोला नहीं गया कोर्ट में कि आपको गवाही देना है, हम लोग रिलाई कर रहे थे अपना, हम लोग प्रोड्यूस नहीं करते। However, having regard to the entire circumstances of the case, particularly when the Labour Court had itself found that the inquiry was not fairly and properly held, we allow this appeal, set aside the judgment of High Court and that of Labour Court, and remand the case back to the Labour Court to decide the case afresh after requiring the parties to leave fresh evidence on merit in pursuance of its order dated April. We direct the Labour Court shall dispose of the whole matter within 3 months from the date on which the certified copies this judgment is produced before it. There will be no order as to post.
तो आपको रिमांड चाहिए? What are you looking for? You want a remand?
नहीं तो ये तो लेबर कोर्ट का जो है सिर्फ यही फाइंडिंग दिया कि चूंकि ये कोई गवाह नहीं करवाए हैं, once it has been held that the domestic inquiry was not fair and proper, तो उसी में हमारा केस को बोला गया I have no other option than to reinstate the person and direct payment of wages। अगर इसी जजमेंट पर रिलाई कर रहे हैं तो हम लोग को अपॉर्चुनिटी देते कि भाई आप अपना गवाही करें। Apart compliance of the Nita Kiplis judgment 1991। और एक पॉइंट हम करेंगे जो हम पिछले डेट में नहीं कहते, विद रिस्पेक्ट टू सेक्शन 36 ऑफ द आईडी एक्ट, हम लोग अपना रिटन स्टेटमेंट में लिखे कि ये जो जनता श्रमिक संघ था उसके ये मेंबर नहीं थे। इसका पैराग्राफ हम लोग का जो रिटन स्टेटमेंट है वो देखा जाएगा पेज 68 में, Annexure 12 of written statement of
आपका ये नेवर एंडिंग कहानी नहीं चल सकता।
तो
ये आपको पूरा टाइम लगा के आपको सुने हैं, आप हर डेट में नया। यस प्लीज। अब आप ये जो बोल रहे हैं ना, ये आपके रिटन सबमिशन में भी नहीं, ठीक है? देयर इज नो एंड टू इट।
नहीं हमारे रिटन सबमिशन जो दिए हैं उसमें
रेस्पोंडेंट
अभी पेज 68
आपको बहस करना है कि नहीं करना? हाँ तो करिए अपना बहस।
खाली पेज 68
नहीं
प्लीज
आई हैव रेड इट नाउ।
पेज 68 देखिए।
यस
हम एक पॉइंट खाली बोल देते हैं,
हम
नहीं
बोलिए
बोल
बस।
देते।
Yes, respondent. I'm asking you. You want to argue or you don't want to argue? Or you argue your case? Tell us. Why didn't you disclose before the authority that you had moved before the court?
The judgment passed in this case is in twofold. First point is to reinstate the work, and second is to pay the damages.
Yes.
So, on the death of the workman, first point,
That we have already recorded.
it became insurance.
We have already recorded.
And second point is that so far the payment of backwards. So only I will state the point that backwards it is necessary in
Where
this
is your
case.
written statement filed before the court? Where is your written statement filed before the court? उन्होंने रिट में तो कुछ भी नहीं लगाया। They have not annexed anything in the deed.
हम लगा दिए एनेक्शन 11 है पेज 64 में तो हमारा स्टे पिटीशन है उसी का एनेक्शन 11 है रिटन स्टेटमेंट ऑफ द बर्थ एनेक्शन 11
Annexure
11 page 64 stay application page 64
इसका सारा रिकॉर्ड सब कहाँ है?
was a permanent grade 2 clerk and had been working since long with unblemished record of service.
कौन सा है ये?
फाइल का नंबर पता है 1722 of 2009
Written statement of the work.
1722 page 64
आईए नंबर 1722 में कोई पेज 64 नहीं है.
फाइल की है उसी बेसिस पे हमको स्टे मिला है इनको
अब
कॉपी है an application and article to constitution for stay of the appeal award stay application
इसके साथ कोई annexure नहीं है.
स्कैन होता है तो
इसका annexure कहाँ है? इसका annexure नहीं है इसमें. खोजिए इसे. Have you stated in your petition, in your written statement, that you were not employed anywhere? Is there any such statement?
वो इनका 17B वाला में
17B तो यहाँ चलता है ना. आप हमको ये बताइए कि कोर्ट में
Order dated 13.
कोर्ट में बताइए कोर्ट में before the learned court, is there any statement that you are not employed anywhere? You remained out of employment for 19 years. Is there any statement that you were not employed anywhere? फुल बैक वेजेस आपको 20 साल का 25 साल का मिलना है ना.
17.
हाँ 17B से नहीं काटेगा बात सर प्लीज. इतना थोड़ा सा इज्जत करिए कोर्ट के प्रोसीडिंग करने. 17B से गाइडेड नहीं होगा whether you were employed or unemployed. Is there any statement in your written statement that you were unemployed?
हम पढ़ लिए
There are 10 में लिखा है कि that the concerned workman to the before the management several times for his reinstatement and approach the different facilities under the ground advice of their board, and the concerned workman also lost his mental balance due to sudden dismissal, resultant poverty, which was disturbance of his mental setup. It is opposite grounds and reason. Masarama could not raise the issue because the consultation officer immediately, and there was some delay on part of the government in approaching before the correct and appropriate authority. The consideration proceeding ended in failure. The government referred the dispute.
When did the conciliation proceeding ended in failure? When did you approach the conciliation officer? No dates have been mentioned, no? Have you mentioned any date? So you were in in unsound mind while you were moving Kolkata High Court.
Wrong advice.
Wrong advice. Case जीत गए तो right advice, हार गए तो wrong advice.
But the important fact is that in the Kolkata High Court, the respondent ACL was
That I have taken note.
implemented as party respondent.
That I have taken
So
note.
they were fully aware.
That's it. They were fully aware. You were not aware that you have moved Kolkata High Court. There is no statement that you are unemployed. Either you show me or I will record it. Either you show me some statement or I will say that you have not been able to point out any such statement from the written statement that you remain unemployed.
Remember, in the 17
17B is a separate proceeding. I'll record that also. But so far as your written statement is concerned, there is no statement.
written statement
देखिए, the learned counsel for the respondent during the course of argument has placed the written statement filed by the concerned workman before the learned court and has fairly submitted that there is no such statement in the written statement filed by the workman that the workman remained unemployed from the date of his dismissal. However, he has submitted that in the petition under section 17B has been allowed by this court and therefore
it has been mentioned that he was not employed anywhere.
wherein it has been mentioned that he was not gainfully employed anywhere and therefore that should be sufficient and it should be taken into consideration that the respondent remained unemployed. That's all. और बताइए क्या बोलना? What else do you want to say? Which judgment you want to place? You place one of every judgment you have cited. You place them. Yes. You have filed some certain judgments. Which judgment? First one, right? Yes. Which paragraph?
One more judgment. This was in 1-5 Supreme Court cases, page 436.
2005, volume 1, SCC.
2001-5. 2001-5 Supreme Court
1,
cases,
volume 5, SCC.
436.
433. Para number? Para?
Classical.
Placitum से मत पढ़िए, please. I don't read it from Placitum. You read the paragraph.
Para 44, 45.
Okay. Line. For what proposition of law do you want to place this?
That remain held. There is no difference whether the matter comes before the labor court under section 33 or a reference under section 10 of the Act. In either cases, the employer has to justify the order of dismissal. So in this case, they have not justified the order of dismissal.
There is no doubt on that. You see, the inquiry was held to be unfair. They did not lead any evidence. There is no doubt about it. That they have done nothing.
Discussion has been.
इसके लिए जजमेंट का क्या जरूरत है? मैं ऐसे ही बोल देंगे. इसमें तो कोई जजमेंट का जरूरत नहीं. They were supposed to lead evidence which they did not lead.
Let's see the para 10 of the judgment. As per the written statement, it shows that the concerned workman informed the duties of the clerk in the month of November and December 1980 and in the month of January and February 1981 regarding base payment of some workers. As per inquiry report, only 50 total in the month of November 1980 and in the month of December 1980 only 110. Between 110, the detail is given. Detail has been given at page, internal page 11 of the judgment.
I don't get it. Why are you citing this judgment? On what proposition of law you are citing this judgment? What is the relevance of this judgment in this particular case? It is an admitted fact that the inquiry was held to be unfair, and it is an admitted fact that the management did not lead any evidence. It is an admitted fact that you cannot be reinstated, you are only fighting for back wages. Isn't it? And it is an admitted fact you moved Kolkata High Court against the order of dismissal, which was dismissed, and against that you filed your LPA, which was dismissed. But your contention is that they did not point it out to the court, and therefore that cannot be taken care of at this stage. Right?
And now they cannot be allowed to gainsay all these things. What they have not stated before the tribunal.
That I have noted and I will take care of it. Now you tell me that you are fighting for back wages. Right? So give me one judgment that if the management does not lead any evidence, then reinstatement is automatic irrespective of the fact as to whether you state so in your written statement that you were not gainfully employed. Show me one judgment. इस जजमेंट का कोई रेलेवेंस नहीं है, नॉट रिक्वायर्ड. क्या चीज के लिए हम ये जजमेंट आपको देते हैं? What all these तो वापस कर.
They started. I have given some judgment.
Yes.
One.
You place the judgment. ऐसा bunch बना के देने से नहीं होगा. You place the judgment. Which judgment do you want to place? One by one. एकदम एक के बाद एक आएगी. पहला LPA number. This LPA judgment, right?
हाँ.
Which paragraph are you relying on? Which paragraph?
2016.
Paragraph.
Paragraph 10 to 13.
10 to 13. On what proposition are you relying upon this judgment? On what proposition are you relying upon this judgment?
On proposition, cognizant.
Yes.
Once charged of submitting the code and verified the document is framed, onus was on management to give adequate evidence to charge.
They have failed, Mr. Mukherjee. I have taken it that they have not led any evidence to justify their charge. So that's the end of the story.
And another paragraph, paragraph 5 and paragraph 9.
Paragraph 5. Scope of 226. Correct?
High Court, while examining legality and propriety of the decision rendered by tribunal, does not seek any appeal over decision of the tribunal. Sufficiency of evidence to weigh on a point is within exclusive jurisdiction of the tribunal.
That's
interference.
Just a moment. The learned counsel for the respondent has referred to the judgment passed by the by this court, reported in 2016 SSC Online JHAR 740. He has referred to paragraph 5 of the said judgment to submit that the writ courts do not sit in appeal, and therefore the scope of interference under 226 is very limited. Next judgment.
There are 5 minutes. Another judgment has been referred. That was the
Same.
mother judgment. So you can say Yaqub.
There is no doubt about it. Mr. Mukherjee, there is no doubt about it. Scope is very limited. Right? And next judgment, 17.4. Which paragraph are you referring to? WPL number 6820.
That is almost on the same point.
Okay. On the same point, he has referred to the judgment passed by this court in WPL number 6820/2012, decided on 17/8/2017. Next judgment.
10 to 7.
Para 10. Next judgment. 1964. On which point? On the same point. On the same point.
Almost on the same.
Right. That is AIR 1964 SC 477. On the same point he has relied upon this judgment also. ये सब ना एक ही point के अंदर डाल दीजिएगा. और 1984 ये किस लिए साइट किए? 1984
2005-3 Supreme Court cases 193.
1984 you are not citing. Okay, 2005-3.
There are 19.
Okay.
The Honorable Supreme Court has read labor laws, back wages, quantum, consideration, current financial capacity of indebtedness, impact financial position, financial transfer. Due to undergoing financial crisis, full back wages awarded by labor court reduced to 50% by Supreme Court. However, retirement benefits accruing due to award of reinstatement not disturbed. There are 19.
Yes, on the point of back pages, he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2005 bracket close 3 SSC 193. Paragraph
5, 6, 12, 13, 16 and 19.
paragraph
Paragraph
5,
5,
6,
6,
hmm,
12, 13, 16 and 19.
12 to 19. Okay? और आगे बताइए which what else? 2014 का भी तो सेम है. That's all.
2004, 6. Just
2014 6.
6.
On the point of back pages.
434.
Bracket
So you have one.
2014 bracket close 6 SSC 434.
So now,
Which paragraph?
paragraph 15, 19, 21.
Para 15,
15, 19, 20.
19 and 20. That's all. Done?
And one submission on behalf of the what means the ECL, Eastern Coalfields Limited, being a model employer of a welfare state, must do justice to its work.
The Learned Council has also submitted that the petitioner, being a public sector organization and a model employer, should not shy away from doing justice to the widow of the concerned. Do you have to say anything in response? Conclusion. Yes, sir. सौरभ, इसका डिक्टेशन आपको दिए थे ना?
Item 2 WPL 623/2026.
Sorry, yesterday I was at
No. Very short. You must have heard it yesterday. You देख लिया होंगे by this time.
Well, so far as I and warrant of arrest are concerned, they have lost their rights. So because
See, it is only constitution. We are on second. For the first time on 6th, the concerned officer asked him to produce certain documents. वो 26 2 वो TBS सर्टिफिकेट होता है एम्प्लॉयर, और वो उसके अलावा जो है TBS सर्टिफिकेट, then books of accounts, and many documents were asked to be brought on record, to which he agreed. And 10th को he paid for something. उस दिन क्लोज करके ऑर्डर हो गया. If he wants to produce these documents, what is your problem? Because it's a very short time. I agree that for so far as the previous dates are concerned, his conduct was not very good.
Then I'm not going on the previous. My submission is this: that since he participated in the proceedings and presuming that he was deprived of ample opportunity of hearing by not allowing to produce, because he did not move in appeal under the statute of 2007. And on the contrary, he submits that give me some time, I will make payments in parts. Since 2022 till 2026, he has not made a single payment. And now he has moved in appeal before this honorable court against the warrant of arrest.
See, I'll tell you one thing. That's fair enough. That during this period, he was asking for installments.
Yes, that is on the record.
Because that was not voluntary, but because they had attached my bank account, they had attached me to stop doing work, and they stopped my payment. That way I was forced to ask time. That is why I asked. I have stated in
You
my
see,
writing.
whatever you want, on any day you want, on any time you want, day and time. They'll come with the records, you verify your records, you can repeat the same order. You see, whenever a person is not producing the records, and then you have to give that, now it's over. By way of last indulgence, you are being given time.
But I am open to Myron's opinion, but I am only afraid of one thing.
Yes.
That this indulgence may not become a precedence, because the otherwise Supreme Court says that statutory provision 7(9), even our High Court division bench also says.
That's right.
So if this becomes a precedence, then
So it can't be. It's an exercise under 226. Only in an appropriate case, such an exercise would be.
Myron may indicate in the order that being conscious, and if I may be permitted to say so, that there are orders of the division bench and Supreme Court statutory appeals have to be exhausted first. And in very extraordinary jurisdiction, if there is laches on part of the establishment of the petitioner of not having moved in right earnest,
That's right.
then if Mallards are indulging, interfering with the matter, Mallard may indicate to that extent that it will not be as a precedence. And in the specific facts of the case, Mallards are passing.
Let's see, almost they have stated in their order that I have submitted some documents on 14/7/2025. It's not the case that I have not submitted any document. I have submitted some documents. I have said for some time. That's all.
14/7.
21.
The learned counsel for the respondent.
Madam may not record my concession to that.
No, I do not. Certainly not. The learned counsel for the respondent, EPFO, has opposed the prayer and has submitted that the petitioner has failed to avail the statutory remedy of appeal against the order of assessment passed under section 7 capital A of the Employees Provident Fund and Miscellaneous Provisions Act 1950. He has also submitted that the petitioner has moved this court only after certain coercive steps were undertaken by the respondent to realize the dues, which included issuance of bailable warrant of arrest,
Right.
bailable warrant of arrest and attachment of bank account. And the petitioner at one stage also made a prayer,
Next is 7 and 8.
made a prayer that he would clear the dues of the organization. The learned counsel submits that under such circumstances, the petitioner is not entitled to any relief under Article 226 of the Constitution of India. And even if any relief is granted, the same may not be treated as reasonable. Yes.
Last.
अच्छा ठीक
Last
Okay,
वाला
ये last वाला line है. The learned counsel for the petitioner in response has submitted that the prayer for giving installment was made under the circumstances when EPFO was constantly following up with the petitioner and was taking coercive steps. He has further submitted that
May I indicate that would be a wrong statement on part of the petitioner. Because the letters of payment, agreement to pay in part, that is 22/8/22 and 19/9/22. But the coercive steps have started on 6/9/22 and 31/7/24. That is subsequent to these letters of agreement to make payment in part. Next are 7 and 8. They are prior to the coercive access.
Recovery officer I have written in the legislature. They had contacted you for the recovery officer I have written in the not before the Provident Commissioner.
was taken when the Annexure 5 dated 3/8/2022. Was it 3/8?
6/9 is the actual date.
दो डेट है
हाँ, वो
3/8/2022/6/9/2022 was issued to the petitioner for realization of the dues.
On 19/9 also I have written Annexure 8.
That should be sufficient. The learned counsel submits that it is not a case where the petitioner has not been participating in the proceedings. rather on 14/7/2021, certain documents were also submitted by the petitioner, which is apparent from the order passed under section 7 capital A of the aforesaid act.
Page 39, second last paragraph.
He has referred to internal page 2 of the order, wherein along with the email dated 14/7/2021, certain attachments were made with respect to salary, PF deduction details of employees engaged at NTPC Barha for 9 months, Chalan of HV Equipments Private Limited, Uttar Pradesh, one of the principal employer of the establishment. The Learned Council has submitted that if one opportunity is granted to the petitioner, all the relevant records will be produced at one go. After hearing the Learned Council from the parties and upon going through the improved order as contained in Annexure 3, this court finds that the proceeding against the petitioner commenced sometimes in the year 2018, and there is no doubt that on a large number of dates nobody had appeared on behalf of the petitioner. However, it appears that after a few dates, the petitioner started appearing before the authority, and EPF application.
small aspect. I find that must be brought to the knowledge of the honorable board. At 893 of 2019, our own division bench order. But there also the petitioner had filed the writ petition without availing the statutory appeal. Because the writ was dismissed. Then he moved in appeal. Nagar was Modi Seva Sadan Raj. The appellate court may have declined to give permit to move in appeal after withdrawing the writ petition. Even that says the statutory period of limitation which is prescribed in the act.
That's what I'm stuck at. वो उसमें तो I think it was my order or maybe I was arguing. I don't remember.
No, my lord was not. My lord had already been elevated.
I don't remember because I know about this. That is why I
This is 23rd February 21 order in LPA 893 of 19.
I was there in the division bench.
My lord, Chief Justice and Honorable Justice.
ये वाला जब order निकाले the 7A में कितना limitation है?
Maximum, my lord, it is
For review, it is 45 days, and for appeal 60 plus 60. 60, 120 days max, they can stand 60.
From the pedestal of the issued order, it is apparent that on 11/11/2020, the petitioner had appeared and he was asked to submit attendance and salary record of all employees of the case period with proof of EPF deposit in principal employer code with respect to concerned employees. He was also asked to submit balance sheet, bank statement, work order, form 26AS. If you see, the proprietor requested time to send the records, and accordingly, the next date of hearing was fixed on 2/12/2020. On 2/12/2020 also, he prayed for some more time. And next date was fixed on 11/2/2021. And thereafter on successive dates, that is on 11/2/21, 11/3/21, 15/4/21, 22/4/21, 12/5/21, nobody appeared. And thereafter on 4/6/21, the petitioner prayed for some more time and the next date fixed was 16/6/21. Then thereafter the petitioner again absented and he sent an email on 4/7/21 with some documents. And ultimately, he again prayed for time on 6/1/2022. And he was directed to produce the documents. The next date was fixed at his request on 10/1/2022, and on that date, the proprietor of the petitioner did not appear, and ultimately the proceedings was closed and the review order was passed. The authority was of the view that enough time was granted to the petitioner to produce the relevant documents, but in absence of such documents, the order in view was passed. On 13/1/2022. It further appears that the prohibitory order that a certificate case was instituted, bearing certificate case number 14355 dated 4/4/2022, and prohibitory order was issued on 6/9/2022, and thereafter the petitioner has been requesting time and again for time and stating that he would deposit the entire amount. However, the petitioner did not take any step to challenge the order passed under Section 7A of the Repression Act. During the course of hearing, it is not in dispute that the appeal against the order impugned has already been barred by limitation, and the prescribed period for limitation to challenge in appeal is 60 days and condonable period of further 60 days.
So page 18 said was there is some the judgment which has been played. Last paragraph at page 18. May I read?
Yes.
Further, the learned single judge has also considered the fact about non-filing of statutory appeal as provided under section 7I of the Act 1952. That also does not suffer from any infirmity as because when the provision of alternative remedy is available, the establishment ought to have approached the appellate authority. More particularly, if the provision of section 7I of the Act of 1952 would be scrutinized, along with Rule 7 of the Tribunal, Rules 1997, wherein it has been provided that the appellate forum, as under section 7I of the Act, has got power to adjudicate the issue on the factual dispute. But the appellant has not chosen to file an appeal and straightway come to the great jurisdiction of this court, as provided under Article 226 of the Constitution of India. And therefore, the learned single judge is right in making an observation that the writ petitioner did not take step for filing statutory appeal under section 7I.
This would find
I will take one.
an order of the in passed in LPA numbers 893 of 2019 has been brought to the notice of this court, which has been pronounced on 22 to 2021. Paragraph 13. And also the paragraph 14, wherein it has been observed that the total period, the maximum period for filing the appeal is 120 days, within bracket 60 plus 60 from the date of issuance of the order. This court finds that the petitioner did not avail the alternative remedy within the statutory period.
The point of alternate remedy, paragraph 87. There are 4 exceptions to the alternate remedy.
Just a moment, I read this. The petitioner did not avail the alternative remedy within the statutory period prescribed and has filed the petition after expiry of how many years?
About 4 years.
About 4 years.
3 years.
11/11/2025, and this is 3/1/2022. Around almost 4 years. Almost 4 years. From the date of the impugned order. And it is not the case of the petitioner that the impugned order was not within his knowledge. Judgment of Honorable Supreme Court has been brought to the notice of this court by the learned counsel for the petitioner reported in bracket 2024 bracket 26 SCC 579, paragraph 37, to bring to the notice of this court that the power under Article 226 can be exercised in spite of availability of alternative remedy under certain circumstances. They are note Roman 1, where the statutory authority has not acted in accordance with the provisions of the enactment in question. It has acted in defiance of the principles of natural justice. It has resorted to invoke provisions which are repealed, and when an order has been passed in total violation of principles of natural justice. This court is of the view that, considering the issued order, none of the aforesaid circumstances in which Article 226 of the Constitution of India can be exercised in spite of alternative remedy.
There is no specific case in
Can
paragraph
you-
21 that there is a lawsuit method of measure that is
Is attracted in the present case. So far as the challenge to the order dated 3/1/2022 passed under section 7 capital A of the aforesaid act is concerned, this court also finds that ample opportunity was granted to the petitioner to produce the documents right from 2018 where the petitioner failed to produce and also did not challenge the order within the prescribed period of limitation. This court is not inclined to exercise power under Article 226 of the Constitution of India. And accordingly, the order in view does not call for any interference. A warrant of arrest क्या क्या बोलते हैं?
मार्च 25 तक के लिए
इनका इंटरेस्ट तो नोट कर दें.
ये पेज C51 of the writ petition. That is the warrant of arrest.
With respect to the warrant of arrest issued against the petitioner, at page 51 is concerned, it has been pointed out by the learned counsel appearing on behalf of the respondent that
It was returnable by 31st March 25 at the last paragraph.
look at this has become
It cannot be invoked any further unless I issue another warrant.
okay. The learned counsel for the respondent has submitted that the said warrant of arrest has become the prayer challenging the warrant of arrest dated 19/2/25 has become infructuous in view of the fact that the warrant was made returnable on 31st of March 2025 and the period has already elapsed. He submits that unless a fresh warrant of arrest is issued, the impugned warrant of arrest has lost its force completely. Having recorded the learned counsel for the respondent as above, with respect to the warrant of arrest, no further pronouncement is required from this court. आपको इंस्टॉलमेंट चाहिए तो बता दीजिए, अभी दे दूँ.
That would be the best option for him.
आपको चाहिए तो अभी दे दूँ.
That I have to see
Instruction क्या?
I'll
Come, if you want any installment, I'll give you the installment. Installment में तो आपको कोई तकलीफ नहीं होगा.
तो collection करना मतलब for the benefit of the
My
laborers.
was liberty may be given.
I will not give you that liberty. I can't give you that
I
liberty.
think they have not applied the documents which were relevant.
आपका अपील नहीं एंटरटेन हो सकता और आपका पीरियड ऑफ लिमिटेशन यहाँ से कंट्रोल नहीं कर सकता. That is not permissible under law. ये नहीं होगा. वहाँ तो बिल्कुल ही आपका यहाँ से इंस्टॉलमेंट में मिल जाएगा, वहाँ तो वो भी नहीं मिलेगा. आप आइए, अगर आपको इंस्टॉलमेंट में पेमेंट करना है, इजी इंस्टॉलमेंट कर देंगे. यू जस्ट आस्क हिम, आई गिव यू इंस्टॉलमेंट. ठीक है, इसमें तो कंसर्न में कोई दिक्कत नहीं है. चलिए.
But in default, Lord, he will lie in contempt.
Sorry?
In default of that installment, he will lie in contempt.
चलिए. Okay. एक ये तो खत्म हो. एक और पार्टनर
Parted from daily list, item 1 WPL 175 of the content.
So for the delay, Madam, I have one WPS number given by you, which is number is the report must the order
Delay
sheet.
means?
Order sheet is the available information.
No, what do you want?
It,
Where is Mr. Mehta? He's not here. He was here right now.
It was raised that after such a long delay, it has been filed, it has been filed, by the reference has been made. But the reason is that the reference was rejected and thereafter lead petition was filed to this honorable WPA number 1021/2003.
You are the respondent.
I'm responding.
First, let him argue his case. Yes, yes.
In fact, that started and the Lordship has taken note of my argument also.
Yes. Mr. Sinha,
No,
his main point for argument was
no.
that you were already terminated in 1995. And
There-
therefore,
there is no
there could
termination.
have been.
No termination order, only stopped without
No,
giving notice.
no, you have stated so in your written statement that you were terminated.
Stopped
No.
from working.
No,
No termination order, only stopped.
to the extent of terminating the services of the concerned workman with effect from January 1995. This is at page number 35, para number 11.
Actually, they were not, no termination notice there. No termination
We need
order.
not be there. That is your stand.
No termination order, no.
We are not bothered about it. This is your stand that you were terminated from service in January 1995. Then how do you claim regularization in 2003? That is his entire case.
The reason of delay. So for delay is concerned, the reference.
We are not on delay. We are not on delay. When a person has already been terminated in 1995, how can he seek regularization in 2003? Unless the order of termination is set aside.
There is no order of termination.
We do not know. You have stated so in your paragraph 11 that you have been terminated from service from 1995.
It has come later on
That what?
that they were not terminated.
Where show me one. Show me the finding.
Not terminated, not stopped from the work.
From where do you say this?
They were stopped from working. I am page number 4, internal page 4, page number 48.
You see, you have to stick to your written statement, right? Whatever you might have said, you show me from your written statement that in spite of order of termination, you were continuing to work. Because your evidence will not go beyond your written statement, isn't it? Where is it?
It is forgotten now. Right. The statement is clear. Written statement has been filed on behalf of workman stating the why I am reading paragraph number 2. The written statement has been filed on behalf of the workman stating that P.S. Sukram and 29 others concerned workmen had been working as a permanent workman in Alkusha Colliery, Siswam, which have been unblemished record of service. Concerned workmen had been working in permanent pavilion nature of job such as timber, weather, walking, etc. They were working in permanent nature of job, continuously under the direct control and supervision of the management. They were rendering their services and producing goods for the benefit of the management. All the elements for execution of the job were being supplied by the management. The management has implemented wage board recommendation and national promise agreement. They were performing the job within the distinct of the premises of the mind and job which was they were performing a permanent in nature as per wage board recommendation etc. And according to all the concerned workers were entitled to receive wages and other benefits as per NCWA. The management with a malignant intention to deprive the concerned workmen of their legitimate wages and other benefits was not maintaining a statutory record regarding the concerned workmen, and management used to disperse their wages for below and prevailing rate of wages in the name of intermediaries. The disbursement of the wages in the name of intermediaries was nothing but a legal commercial. The concerned workmen approached the management several times for their regularization and wages as per NCWA, but without any effect. They insisted for regularization and invited the management to the extent of terminating the service of the concerned workmen with effect from January 1995.
Yes, that
By stopping them, here is the line, by stopping them from work without assigning any reason or without complying the mandatory provision of
just a
law.
moment. If the mandatory provision of law is not complied, which provision of Industrial Disputes Act is attractive?
It has been raised unless
Which provision of Industrial Disputes Act is attractive if the mandatory provision regarding termination is not followed? 25F?
25.
25F? Right? It is not a case of 25F.
It is sorry.
It is a case of regularization.
Only for these pilot, there is a judgment of the apex on this issue.
Which judgment is that?
This is pilot 2008 12 ACC
2008.
12 ACC
2008?
volume 12
Volume 12 SCC
ACC 275.
27. What does it say? Where is that judgment? Sorry?
I'm just reading the living tax. The High Court has authority to inquire as to whether the finding a right to act by the industry tribunal is based on evidence and to correct the error apparent on the face of the law. The High Court is fully justified in interfering with the award of industry tribunal on account of patent illegality. It has also been justified if it is contrary to law laid down by the Supreme Court and passed as a measure of this sympathy, and thus perverse interference in such cases is limited to the few cases where there is patent illegality and perversity. There is, however, no perversity and patent illegality in the award of the industrial tribunal has minutely examined the evidence. So far, other things are concerned. Only section provision of law is not taken into consideration. 25F. Then, under such circumstances, it may be taken into consideration that the tribunal has appreciated, minutely examined the evidence in arriving at a decision, and it has behaved that it was not proper for the single judge of the Honorable High Court to reappraise evidence and come to a different conclusion.
We are not doing so. We are not doing so. Not at all.
I noticed 25 so far, 25 is concerned.
It is not a case of 25. It is a case of regularization.
Regularly.
So,
Therefore,
you have been terminated. How can you regularize?
Regulation word is there, but one line is also there. That one line is also there, which is terminated with effect from January 1995 by stopping them from work without assigning any reason, without complying with mandatory, without assigning any reason. They stopped, no order of termination. So regularization was in process. Always assurance was given. They were under expectation that their service is to be regularized. Under such expectation, they were regularly insisting the authorities.
In absence of any reference regarding your illegal termination, how are you entitled for regularization?
This is a regulation, there are several judgments which have been considered by the Award.
You only one, you need to answer only one question. इसके अलावा आपको कुछ नहीं answer. When you are already a terminated employee, how can you be regularized? And if that termination is without following the procedure of law, the remedy is under 25F, and there is a provision for payment of compensation. You are not to be reinstated.
Now, my lord, present my lord, this is the order of. Now, this is what we stated there. They have already attained the years of prohibition.
That's right.
They have already, but so far 50% back wages is concerned.
There is question of back wages.
This order has been taken, they award, this is what.
We cannot go beyond law. Which judgment are you relying upon, Mr. Mehta?
2015 4SCC 471, paragraphs 22 to 30. That is it.
Yes.
It is thus clear that appropriate government is empowered to make a reference under Section 10 of the Act only when industrial dispute exists or is apprehended between the parties. Similarly, it is also clear that tribunal, while answering the reference, has to confine its inquiry to the question referred and has no jurisdiction to travel beyond the questions or and the terms of reference while answering the reference. A fortiori, no inquiry can be made on those questions which are not specifically referred to the tribunal while answering the reference. Coming now to the facts of this case, it is an admitted case that the services of the appellants and those at whose instance the reference was made were terminated long back prior to making of the reference. These workers were therefore not in the service of either the contractor and or BCCL on the date of making the reference in question. Therefore, there was no industrial dispute that existed or apprehended in relation to the appellant's absorption in the service of BCCL on the date of the reference. Indeed, a dispute regarding appellant's absorption was capable of being referred to in a reference for adjudication had the appellants been in service of the contractor or an BCCL. But as said above, since the appellant's services were discontinued or and retrenched, whether rightly or wrongly, long back, the question of their absorption or regularization in the services of BCCL as claimed by them did not arise, and nor could this issue have been gone into on its merit for the reason that it was not legally possible to give any direction to absorb, regularize the appellants so long as they were not in the employment. 25. It is settled principle of law that absorption and regularization in service can be claimed or and granted only when the contract of employment subsists and is in force inter se employee and the employer. Once it comes to an end, either by efflux of time or as per the terms of the contract of employment or by its termination by the employer, then in such event the relationship of employee and employer comes to an end and no longer subsists except for the limited purpose to examine the legality and correctness of the termination. In our considered opinion, the only industrial dispute which existed for being referred to industrial tribunal for adjudication was in relation to termination of the appellant's employment and whether it was legal or not. It is an admitted fact that it was not referred to the tribunal and therefore it had attained finality against the appellants. In our considered opinion, therefore, A reference, even if made, to examine the issue of absorption of the appellants in the service of BCCL, the same was misconceived. Apart from this infirmity noticed in this case, we have also not been able to find any parity, and it's a case of.
That's
This is all.
the
So
learned
here-
counsel for the respondent has submitted that there is no scope for interference in the improved award and there is no perversity. Yes, further, in response to paragraph 11 of the written statement filed by the concerned workmen, has submitted that the workmen were discontinued from service without assigning any reason and without complying with the mandatory provision of law with effect from January 1995, but no termination letter was issued to them. He has submitted that the order of regularization with effect from 1/1/1995 with 50% back wages has been rightly made. After hearing the learned counsel for the parties, this court finds that by a reference order of reference dated 22/8/2003, the central government in the Ministry of Labour made the following reference to the central government industry tribunal number 1 Dhanbad under section 10 within bracket 1 within bracket D within bracket 2 capital A of the Industrial Disputes Act 1947. The terms of reference is quoted as under. The reference was essentially relating to regularization or granting the relief of permanency to one Ashok Ram and 29 others, which was demanded by the union, namely Janata Mazdoor Sangh. However, the workmen, when they filed their written statement, raised a specific plea that the management had terminated their services with effect from January 1995 by stopping them from working without assigning any reason and without complying with the mandatory provision of law. Paragraph 11 of the written statement filed by the concerned workmen is quoted as under. This court finds, and as has been rightly pointed out by the learned counsel for the petitioner, that as per the case of the workmen themselves, they were terminated from service with effect from January 1995. But no reference was made with respect to legality and validity of the alleged termination with effect from January 1995. Rather, the reference was for regularization of the concerned workmen. And the award has been passed for regularization of the concerned workmen from with effect from 1/1/1995 with 50% back wages. Although their services as per the concerned workmen stood terminated with effect from January 1995. That is much prior to the date of reference. This court finds that although the stand of the workmen has been recorded by the learned labour court, but the learned labour court has completely lost sight of the fact that the concerned workmen who were not who were already terminated way back in 1995 could not have been regularized considering the terms of reference which was essentially for regularization of the concerned workmen. In this regard, the learned counsel for the petitioner has rightly referred to the judgment passed by the Honorable Supreme Court reported in bracket 2015 bracket close 4 SCC 71 paragraph 22 to 27, which is quoted as under. In the aforesaid judgment, the Honorable Supreme Court has categorically observed in paragraph 26 that in the facts of the same case, the only industrial dispute which existed for being referred to the industrial tribunal for adjudication was in relation to termination of the concerned workman. And the same was, and no such industrial dispute was referred, and therefore it was held that the reference, even if made to examine the issue of absorption of the appellants in service of BCCL, was itself misconceived. This court is of the view that on the face of the admitted fact of the concerned workmen that they were terminated from service way back in 1995, no relief of regularization could have been granted to the workmen with effect from 1/1/1995. In such circumstances, the award is perverse and the same is revised.
They already passed with this on the preference and this on the audit, the respondents had moved before this one would go thereafter. That is in the PL number.
Where is that order?
That is the department. It was not from the office.
अच्छा हाँ, कहाँ है वो? It has been brought to the notice of this court. The order passed in WPL number 6195 of 2002, wherein the order of the union government refusing to refer the dispute for adjudication was set aside. And the appropriate government was directed to reconsider the matter and pass an appropriate order this court, from the perusal of the earlier order, finds that the fact that the workmen were terminated in the year 1995 was not brought to the knowledge of this court, and the fact that they stood terminated from 1995 was brought before the learned labour court by none less than the workmen themselves, by making a specific statement in the written statement that they were terminated by the management in the year 1995 itself. Accordingly, the order passed in WPA number 6195 of 2002 does not help the respondent in any manner.
So Supreme Court 2012 PCC
ये तो आपका था ना लिमिटेड स्कोप, ये तो कौन सा पैरा है आपका?
तो पारा जोशी का पारा 1516
15, 16,
पारा
16.
15, 16, 18
इसका जरा एक बार कोट कर देंगे तो 2008 का वॉल्यूम 12 SCC 275 पैरा 10, 15, 16 and 18 which deals with the इसको कोट कर देंगे. Allowed.
Item 2, WPS 6380 of 2010.
Also, NBC declared in the recognition. Paragraph 1, which is also there, that is very just. That in the instructed application, petitioner pays for quashing the findings dated 6/9/2010 of the presiding officer of Labour Court. In MJ case number 13 of the 2009, whereby and wherever the learned Labour Court has been pleased to allow the application filed under section 33C2 of the ID Act 1947 and to pay a sum of rupees 77,367, although the identity of the respondent is yet to be established pursuant to a division bench judgment of this Honourable Court dated so and so by the presiding officer of Labour Court, and for non-compliance of the said order judgment dated so and so, the union, namely Bihar Shramik Sangh, has filed a contempt case, in contempt case number 9 of the 2004, which is still pending. This is my
case number 9 of 2014.
So, I'll first take your lordship to that division bench judgment, which is at page number 29 times. So this is the division bench judgment, and the operative portion, it's a short judgment may place in mind. Yes. This appeal is filed by so and so. The litigation started since 1982 when the Central Administrative Dhanbad in so and so passed an award on 17/9/82, whereby the claim of the workmen was accepted and they were directed to be reinstated, then with full back wages. The concerned workmen then moved this court seeking direction for implementation of award in CWJC number so and so, which is the subject matter of this appeal. 20 workmen represented by the union sought a mandamus upon the appellant for implementation of the award by reinstating 20 workmen, details of which were given in para 40 of the writ petition. The learned single judge, while allowing the writ petition, directed the appellant management to implement the award by reinstating 20 concerned workmen. So as the learned counsel for the appellant has not disputed the fact that award passed in 1982 was affirmed up to the Supreme Court. Learned counsel submitted that there is only dispute with regard to proper identification of the concerned workmen who are entitled to be reinstated pursuant to award passed in 1982. Learned counsel produced before us a copy of the order dated 5/7/2001 passed in Jersey number such, wherein similar question arose with regard to implementation of the same award, and the division bench of this court disposed of the application by issuing certain directions upon the appellant management. Both the counsels agreed that this appeal may also be disposed of in terms of order dated so and so. We also find that only dispute with regard to proper identification of the concerned workmen. We therefore, without interfering with the impugned judgment passed by the learned single judge, further direct the management to approach the Central Industrial Tribunal, Dhanbad, who shall provide every information and hand over the photographs, etc., to the management. The management then shall get the advertisement published in the newspaper within 2 weeks from the date of receipt of the information from the tribunal. After proper identification, the concerned workman shall approach the management within 2 weeks from the date of publication of the advertisement in the newspaper, and the management shall complete the process of identification and reinstate those workmen identified by the management within 30 days from the date of the appearance of the concerned workman. So this was the formula. This was the direction given to the tribunal to make identification, they were to hand over photographs. So what happened thereafter? They approached the tribunal and made application for supplying the documents etc., which were never provided to us. And the tribunal also did not hand it over to them. The documents, as a result of which this contempt application 9 was filed before this honorable court, and the same remained pending before this honorable court hours at the time of filing of the writ application, which is evident from annexure 4 page 31. This is the information that I got. This is case number 9 of 2004. The current status that was shown, the last paragraph was pending. So they had come to this court filing a contempt application against the presiding officer of the central government.
This is CMP number 203 of 2000. Subject CMP number 203 of 2000.
And this one at the top you will also find. It is in fact a contempt application. Case number 9. At the top, third line was after this.
Patna High Court registered at Jharkhand High Court. What is this?
That at that time you are having this.
Petitioner of that case was not Bihar Shramik Sangh. It
This
was
was
some Sohavati Devi. We have got the order of contempt case number 9 of 2014. And you have paid the amount, admissible amount to that lady, and then the contempt was brought.
This is contempt 9.
Yes. Contempt 9 of 2014.
Year?
9 of 2004.
2004.
Yes, that is what we.
ये गलत है।
2014 का
2014 का
वो नहीं है उसको बना
लेकिन ये CNP दिखा रहा है 2003 और 2002 सब्जेक्ट।
This is. If your lordship sees at the top, kindly see the second line, nature of case contempt. Cont is written there, and the next line, case number 9, year 2004. And the parties is Bihar Shramik Sangh, who is also here, the same party. And Dimulendu Biswas was the presiding officer, Central CGIT. Delhi.
डिस्पोजल है 2004 का है।
2004 में डिस्पोजल है,
Yes.
2004 में ही डिस्पोजल है। प्लस से बता रहे हैं, हम नहीं जानते।
नहीं, हमारे पास तो जो
9 of 2004 को देखिए,
9 of 2004.
Second 9 of 2004
Yes.
डिस्पोजल 2004 का है। पार्टी ने बिहार से लीड था।
हाँ, डिस्पोजल है 2004 में।
Can I see the record because this was.
You get the record, मगर ये record नहीं है। इससे क्या फर्क पड़ेगा? एक
नहीं,
बात
फर्क ये पड़ेगा।
बेटा you just tell us, we are against an award. आप कहाँ से कहाँ read petition की तरह मत बहस करिए।
अच्छा ठीक है।
अवार्ड में बताइए आप उनको।
नहीं, अवार्ड में जो था
33C2 का अवार्ड है। He was one of the persons.
one of the awardee
Yes, one of the
in whose favor the award has come
Yes.
and I have to implement it.
Yes.
Only difficulty that I was facing was with regards to identity. Nothing else.
आप किसी का आइडेंटिटी को ना 50 साल तक मत आइडेंटिफाई करिए।
कोई बात नहीं, मगर even if I accept it, अगर उसको भी accept कर लेते हैं, the amount is not going to be, right? So, but my stand is this, that pursuant to the division bench judgment, these persons were not identified, including the respondent in this case. That is my case. The labor court holds in this case that there is no dispute of identity. I'll show that question also.
So that is enough.
Sorry. But
That's
that finding of fact should be based on some material, some record.
You must not have disputed his identity. That is why there is a finding that there is no dispute of identity.
So the labor code also notices all these specifics. Anyway, Manus, I am not going to. This is my submission. Kindly see page 49 from my movement colors. Sorry, finding where he has recorded. And then I will proceed on page 48 colors. Page 48.
Yes, just give me 1 minute.
Yes. Which is part of para 17.
Petitioner का वो respondent का क्या नाम है? प्रेमलाल है। इनका नाम लिस्ट में है।
हाँ, is there? There's no doubt. आंसर लगाया है?
There is no doubt.
There's no doubt about it. There is no doubt about it. In fact, I have given a table which shows connection 5. And these are the persons who could not be identified. 26%, that is at connection 5, case 32. The last name is of Premlal Rizvi. So,
कुछ नहीं है Mr. Rafi is questioning.
let us come back to
You just confine yourself whatever. ऐसा कुछ नहीं
that
है।
there are a submission that is all for us. And the last occasion I also referred to an interest portion.
Yes.
Just hand
Interest
over.
portion will take care of. Will be done.
वो भी एक पॉइंट था रेफर है तो आई कैन
इंटरेस्ट आपको स्टैट्यूटरी मिलता है। We have held in one judgment that labor code को 33C2 में क्वांटिफिकेशन के बाद इंटरेस्ट देने का जुरिस्डिक्शन नहीं है, क्योंकि it is to be realized as a certificate proceeding And under the certificate proceeding, there is a provision for statutory interest.
But by taking into consideration only one aspect, so that the public petitioner, respondent is working as a sweeper, and right from 2010.
वो सब से क्या मतलब है? आपको वो सब का I am not going to interfere with the finding of fact of the labor code so far as your identity is concerned. But so far as your interest portion is concerned, that falls for interest.
And the last finding, that is the order part is concerned. I also would like to see it. It is like paragraph 90 at page 50. Just for
Page 50. Yes.
I hereby confirm the calculation chart revealing dues with effect from
Calculation is not disputed. He is disputing the identity.
But you are not the rightful person to receive.
So only 80% has been awarded. Computed.
You are not in a meeting.
Yes.
They are not challenged.
That's the
I am not bothered about it. You are happy with this.
right.
Heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner has submitted that there is a checkered history with respect to regularization of number of workmen, including one Prem Harijan, who is the respondent in the present case. He has referred to, he has submitted that ultimately the matter was taken up in NPA number 328 of 1998, wherein it has been observed that the litigation started in 1982 when the Central Industrial Tribunal Dhanbad in reference case number 48 of 82 passed an award dated 17/9/82 whereby the claim of the workmen was accepted and they were directed to be reinstated with full packages. The workmen then moved the High Court for implementation of the award in CWJC number 2046 of 1996. The learned court had allowed the petition directing the management to implement the award by reinstating 20 concerned workmen. However, at the same time, a direction was made for proper identification of the workmen who are entitled to be reinstated pursuant to the award in 1982, and the modalities for the same was also mentioned therein. The short order passed in NPA number 328 of 1998 is quoted as under. The learned counsel has then submitted that the process of identification of the workmen was never completed, and consequently the petitioner was not, the concerned workman involved in the present case was not identified, and accordingly a petition under section 33C2 of regarding computation of his wages was itself not made. The learned counsel has submitted that the learned court has recorded that the identity of the concerned workman was not in dispute. However, such finding is perverse. He submits that once the identity is not proved, there is no question of payment of any wages under section 33C2 of Industry Disputes Act. Additionally, he has submitted that in WPA number 6969 of 2017, decided on 19/6/2023, it has been held that there is no scope for passing an order for payment of interest on the computed amount under section 33C2. The learned counsel has referred to paragraph 27 of the said judgment. He submits that the award under section 33C2 is recoverable as through certificate proceeding, and therefore the same is recovered in the same manner as arrear of land revenue. कहाँ लिखा है statutory interest? Have I mentioned it?
Explain. The earlier judgment which the was quoted,
हाँ वो दूसरा judgment है ये
वो
नहीं।
उसमें कोट किया हुआ है इसमें
ये वो judgment नहीं है। ये वो judgment नहीं है Mr.
don't this I have a judgment of your lordship, an exhaustive judgment. There I find the lordship has held, however, in case the computed amount is sought to be recovered through any certificate proceedings, the statutory interest as applicable to the certificate proceedings
So this is
will
what.
be payable.
This
You
is
want,
what.
may I give this
Case
certificate?
certificate.
Yes, sir, for some, may go in
He has relied upon the judgment passed by this court
here. In,
WPL.
this- in WPA 6969 of 2017,
6969 of 2017.
disclosed on 19/6/23,
1960.
and the paragraph would be, paragraph is 29.
He has relied upon the judgment passed by this court in WPL number 6969 of 2017, decided on 19/6/2023, para 29. To submit that it has been held that once the amount payable under section 33C2 is quantified, it is recoverable as certificate proceedings, and the statutory interest in terms of the certificate proceeding is realizable. And there was no scope for the learned court to award interest at the rate of 10% as has been awarded in the press release. The learned counsel for the opposite party has submitted that there is a clear finding that identity of the petitioner was duly established. And therefore, there was a pre-existing award and the petition under section 33C2 was rightly entertained and the award was rightly passed. He submits that so far as the quantification is concerned, the same was also not in dispute. He has further submitted that only 80% of the computed amount has been directed to be paid, and therefore the improved order does not call for any interference. After hearing the learned counsel for the parties and after considering the facts and circumstances of this case, this court finds that the learned court, after referring to the materials on record, has given a clear finding with respect to the identity of the concerned respondent. This court also finds in such circumstances the argument of the petitioner that in spite of the order passed in the award way back in 1982, the award was not capable of implementation as the identity of the concerned person was not established is completely misplaced. This court further finds that the computation which was placed on record was not in dispute, and the court had directed payment of only 80% interest of the computed dues, considering the gainful engagement of the respondent during the relevant period. In view of the aforesaid facts and circumstances, this court does not find any reason to interfere with the impugned order so far as identity of the concerned respondent and the quantum of and the awarded amount is concerned. So far as the interest is concerned, the finding of the learned court calls for interference in view of the judgment passed by this court in the DPL number 6969 of 2017, dated 19/6/2023, paragraph 29 is quoted as under. Consequently, the impugned order does not call for any interference except to the extent it relates to payment of interest at the rate of 10% per annum from 21 to 2009. That's all.
Yes.
Installment चलेगा?
There are guidelines for people who will
In terms of this, एक दे दीजिए बस. At the end, at this stage, the learned counsel for the petitioner has referred to the circular issued by Employees Provident Fund Organization, which is dated 11/2/2014, and has submitted that as per the said circular, the installment facility can be availed by the petitioner in to liquidate the amount in arrears in 36 installments. We submit that appropriate direction be issued so that if an application is filed by the petitioner for consideration of fixing of installment, the authority may fix the installment in terms of the same. To this, the learned counsel for the respondent has no objection. Accordingly, it is observed that the petitioner may
That kindly observe that no proceeds. For that trade only, for the trade granted
uh, the liberty is reserved with the petitioner to move whom? Commissioner?
Regional Commissioner 1 Karachi.
Regional Commissioner 1 Ranchi Zone for fixing the installment to clear the amount in terms of the circular dated 12/2/2014 within 15 days, within 4 weeks from today, and if such an application is filed, appropriate order will be passed by the concerned authority. And if any installment is fixed and the petitioner abides by the payment in terms of the installment, there could be no reason for the authority to take any coercive steps against it. इसको लगा दीजिए इसको.
From supplementary list orders item 3 DT.12.05.2026 of 2006 along chapter 4.
Just an absent. Nobody appears on behalf of the parties. This is for non-prosecution.
For case filing item 5 DT.13.28 of 2026.
What is the nature of the law?
Yes, the dispute was whether the employee was awarded a punishment of removal from service with superannuation benefit, that is pension and PF. He raised a dispute that he is also entitled to leave encashment. Other benefits were paid by the bank. The bank disputed it, he raised an industrial dispute. The industrial tribunal passed an order that he will be also entitled to leave encashment. The only dispute is with regard to leave encashment.
Was I ever involved? I was ever involved in this case. Do you have any idea? ऐसा कुछ नहीं है ना? You have to bear the responsibility to this. ऐसा तो कुछ हमको दिख ही नहीं रहा है, लेकिन I just wanted to ask you.
I also saw the documents in Dhanbad का industrial tribunal.
धनबाद का इंडस्ट्री अवार्ड दिखाइए तो
Award is at page number 87.
25 का है.
G.
So why would you want to pay the leave encashment?
He was removed from service after departmental closing. But as per the award, a punishment was incorporated that some employees may be removed with benefits, retirement benefits. So the bank maintains that retirement benefit will include pension and gratuity and PF, but will not include leave encashment.
How do you say this?
On the basis of this document, which was
Leave encashment is very much an integral part of retirement.
salary. But on the removal from service, he loses the right to leave encashment.
From where you say, you must be having some rules. Some regulations.
Page 79. 79 was the document which was exhibited that contains, as per it, we follow the rules of the Central Civil Service, as per which at page 84, the second column, whether leave encashment can be sanctioned for government servant on his dismissal, removal from service. A government servant who is dismissed, removed from service, ceases to have any claim to leave at his credit from date of such dismissal as per Rule 9(1), hence he is not entitled to any leave encashment. But this is the case of the
Page number?
page I'm reading 84. This was exhibited, this forms part of the documents exhibited starting from page 79. However, I must at least
From the date of dismissal, no?
dismissal removal.
Yes,
Yes.
but the leave encashment must be, the period of leave must have accrued prior to dismissal.
But the CCS rule says that it will be forfeited. Now, before I proceed to the judgment, one judgment is against you on this issue. I must point out before your lordship. Please. There was a clear nature of dispute, and the Honorable High Court have read that to the intent. One issue. So this decides, in fact, against what I am against me. But as issue was not considered in this judgment matter, which is something that trying to draw some benefit from this Ashok Kumar Mishra judgment. The issue was not considered whether removal as per the CCS rules will entail forfeiture or not. Simply it was held that the award employees
See, we are
cannot
not
be
under
discredited.
226. Generally, which is against
It's
an
a
award.
point of law, not factual dispute.
You see, the new point of law also need not be raised under 226.
But this was placed, madam. This document and placing was the exhibit, madam.
That's right, but the point is
This
fully
issue,
covered.
and Jitendra Mishra, in fact, referred to the doctrine of subsidiarity, saying that the earlier Dunna Pandey and its affirmation before the Honorable Supreme Court, leave encashment cannot be withheld. The rules were not properly appreciated and placed. So we will reappreciate. That is what Jitendra, 5 judges bench of this Honorable Court has held. So
That is too long drawn into a
I'm
challenge an award.
trying to make. So I fairly pointed out the judgment that
That's
I
right.
shared.
That fairness I appreciate.
And the ground that I am urging before Lordship, that this issue was not actually agitated there. And in fact, Jitendra Mishra also took note of the principles of doctrine of sub-silence and saying that this issue, though it held that he is entitled to leave encashment, it cannot be withheld, but the rules in that regard were not placed before the court or interpreted.
Which rule was not placed?
But this which is exhibited, matter which we say that the CCU, Central Civil Servant, leave encashment rules will provide the case. Page 79 onwards. This was an exhibit before the matter and filed the photocopy of the exhibit itself. So we say that this
Page 79.
Yes, 79 onwards. At page 84, it says that the leave encashment will not be entitled where there is a case of dismissal or removal from service. He ceases to have a right. Question number is serial number 2, my lord.
Serial number 2.
Yes. A government servant who is dismissed or is removed from service ceases to have any claim to leave at his credit from the date of such dismissal as per Rule 9(1), hence is not entitled to leave encashment. And Jitendra Mishra on similar lines, my lord, if I may kindly see para 59 onwards. Jitendra Mishra is the 5 judges of our court, in which Purnam Mishra was the first.
Para 59.
59 onwards. So it was interpreting the Jharkhand rules. Coming to Jitendra, that is 2025 1 High Court cases, Jharkhand 71 SCC.
Yes.
Coming to Jitendra Kumar Srivastava, we have already noticed that the said case the party respondent was denied both pension and leave
encashment on grounds that there was a tendency of departmental of the criminal proceedings. The Supreme Court therefore had to decide the entitlement of the treatment for both parties. It however referred only to the rule relating to grant of pension, that is Rule 43A and B of the Bihar Pension Rule, and did not deal with any rule allegedly conferring the right to receive leave encashment or the provision taking away the right of an employee to get leave encashment. No doubt it also held in favor of the respondent therein on aspect of pension gratuity and also leave encashment, but the point relating to leave encashment had not been argued or considered by this court. In such circumstances, although leave encashment was logically involved in the facts and although the case had a specific outcome, the decision is not an authority on withholding of leave encashment. The said issue we hold at past sub silence and so the said decision having been rendered without any argument on the aspect of withholding of leave encashment and the statutory legal regime governing the same cannot be said to be a precedent and binding on this court. Also in this case, the question was only with regard to withholding of pension gratuity and leave encashment during pendency of departmental criminal proceedings. Supreme Court was not considering whether the respondent in that case was entitled to be.
What was the punishment awarded?
Removal from service with pensionary benefits.
Removal from service
Yes.
with
Yes.
pensionary benefits.
Yes.
Just a moment.
Right.
The past service is not being prohibited. Once you award pension, pension is primarily based on the past service. And if the past service is not forfeited, like you just see para number 68 of this our full bench,
Yes.
right?
Just one thing before page 70, if you watch me kindly see the punishment. That was also executed. This was the award. Page 70 of the brief.
Yes.
Why I am contending that it will exclude it. Specifically refers the benefit that we were to get. Page 76B. Page 70.
70.
There are perhaps two page number, one has been struck off. 67 has been struck off, 70 has been made number.
Yes. 70.
Yes, 6B.
Yes.
Be removed from service with superannuation benefit, that is pension and or provident fund and gratuity, as would be otherwise under the rules or regulations prevailing at the time. So this was the contention of the time, that the pension, PF and gratuity was entitled to be paid.
But it is absolutely silent so far as leave encashment is
It's as applicable under the rules. So rules say that the leave encashment will be forfeited once he is removed or dismissed. This is my contention.
You see, we remove from service, it is not further saying prevailing at the relevant time and without qualification for future employment.
Yes, future employment.
Where does it say, where does it further qualify with the rules?
Rules, that is what is placed at page 79, the document starting at page 79. This says that on removal, as per the CCU rules, he will not be entitled, he will be forfeited. Both reading page 84 is the.
Be removed is one thing, but removal from service with superannuation benefit is another thing. It's not one and the same.
Removal with and with qualification that provident fund, gratuity, and pension.
That's right.
Three more
That's right. But what you are referring is in case of dismissal / removal from service, right? There can be dismissal, there can be removal. If it is simpliciter dismissal, simpliciter removal, he is not entitled to
Yes.
anything.
So, madam,
He is not entitled to any pensionary
this is my
benefit.
submission, madam. Gratuity as would be otherwise under the rules or regulations prevailing at the time.
So
The
gratuity
encashment is forfeited. So what they expressly put therein was pension, provident fund, and gratuity entitlement. This is my.
But this is silent so far as leave encashment.
Leave encashment is not.
For that you want to refer to this.
Yes, ma'am, that is because
But
otherwise.
here also, leave encashment on dismissal / removal.
Is
It is
forfeited.
also not qualifying that removal with superannuation benefit.
Madam, this punishment is specific to the award staffs only. For that reason, madam, as the central government, this was under the award, wherein between the trade union there was a settlement, and then this award came into existence. That this punishment is an effect of this award.
That's right.
So this punishment is not there in any other service except the bank award staff. madam.
And you have this Bank of Baroda judgment.
Yes, Bank of Baroda on the issue. Yes, madam.
Which paragraph?
Bank of Baroda, para 50.
I need to read. It is arising out of the same bipartite settlement?
Yes. It's a 2002 bipartite. Para 12, your worship will get it is the same. Para 12 only Supreme Court there, number is Para 12 is in 2002 bipartite.
Yes.
And page 65, your worship will find that this is 2002 bipartite.
It was dealing with
The
leave
same
encashment?
Yes, ma'am. But
Where is
leave
that?
encashment was a dispute in this case also. It was.
Was the learned counsel pleading on behalf of the petition? This petition has been filed challenging the award dated 13/10/2025 passed by Central Government in District Tribunal number 1 Dhanbad in reference case number 1 of 2018 in bracket Annexure 8, whereby it has been held that leave encashment benefits is included in superannuation benefit. In superannuation benefit, which was allowed by the management and incorporated in the discharge order itself, whereby pension, provident fund and gratuity was allowed. The learned counsel submits that the bipartite settlement dated 10th April 2002 has been placed on record, and the punishment which was imposed upon the concerned workman was under section 6 within bracket B, that is, an employee found guilty of gross misconduct may be removed from service with superannuation benefits, that is pension and stroke or provident fund and gratuity, as would be due otherwise under the rules or regulations prevailing at the relevant time, and without disqualification from future employment. He has then referred to the fact that the employees are governed by CCS within bracket leave, bracket rules 1972, and has referred to the question and answers, frequently asked questions regarding general entitlement of leave, and has referred to question number 2 at running page 84, which is as follows: whether leave encashment can be sanctioned to a government servant on his dismissal/removal from service. Question mark. A government servant who is, that is an answer. A government servant who is dismissed/removed from service ceases to have any claim to leave at his credit from the date of such dismissal as per Rule 9 within bracket 1. Hence, he is not entitled to any leave encashment. The learned counsel submits that in view of the aforesaid frequently asked question and answer, there was no occasion to the concerned workman was not entitled for leave encashment, even if he was removed from service with superannuation benefits. The learned counsel has referred to the judgment passed by the full bench of this court reported in bracket 2025 bracket rules 1 HCC within bracket Jhar 71, and has submitted that there was similar provision in connection with under the Jharkhand Service Code and it has been ultimately held that the employee would not be entitled for leave encashment. He has referred to paragraph 60, 61 and 62 of the aforesaid judgment, which is quoted as under. However, during the course of argument, the Learned Counsel has fairly submitted that has referred to the judgment passed by the Supreme Court reported in bracket 2014 bracket close to SCC 715 and has submitted that this judgment has been taken note of by the Learned Labour Court, Learned Industrial Tribunal, but the CCS leave rules were not placed before the Honorable Supreme Court by passing the same judgment. And therefore, the judgment passed by the Honorable Supreme Court is permanent. It's sub-silence here. However, it is not in dispute that the same bipartite agreement was under consideration by the Honorable Supreme Court. After hearing the Learned Counsel for the petitioner and upon going through the impugned award and considering the limited dispute which is involved in this case as to whether the petitioner, whether the concerned workman would be entitled to leave encashment in view of the aforesaid punishment imposed under section 6 within bracket, under clause 6 within bracket D of the bipartite settlement dated 10th April 2002, this court is of the view that the question and answer, frequently asked question which has been referred to by the Learned Counsel for the petitioner is not applicable in view of the fact that the same was relatable to dismissal/removal, and in the present case it is removal from service with superannuation benefit, that is pension and stroke or provident fund and gratuity, as would be due otherwise under the rules or regulations prevailing at the relevant time. This court finds that the same bipartite agreement was subject matter of consideration by the Honorable Supreme Court in the aforesaid judgment reported in bracket 2014 bracket close to SCC 715, and it has been held that the concerned employee was entitled for leave encashment. This court also finds that the Honorable Supreme Court, by granting the same benefit, has also taken into consideration Regulation 22, which deals with forfeiture of service. So far as the judgment passed by this by full bench of this court is concerned, the full bench has taken note of the fact in paragraph 68 that in case of dismissal of an employee, his entire past service stands forfeited by virtue of Rule 10(101) within bracket A. Consequently, even the benefits such as earned leave relatable to such past service would stand forfeited. In the present case, since the removal since the removal from service was with superannuation benefit, it cannot be said that the entire past service stood forfeited. The full bench judgment passed by this court does not apply to the facts of this case. However, the fact remains that the entitlement of the concerned workman is squarely covered against the present petitioner in view of the judgment passed by the Honorable Supreme Court reported in bracket 2014 bracket close to SCC 715, and the impugned judgment passed by the Learned Industrial Tribunal has taken note of the aforesaid judgment. The judgment otherwise also is a well-reasoned judgment which does not call for any interference, and Article 227 of the Constitution of India. Consequently, this petition is dismissed.
My petition number
226 9. 227 या 6
नहीं
दो सौ छब्बीस में ठीक है petition under 226 is hereby dismissed, finding no perversity in the impugned